Hi, my name is Paul Stradowski, president of the HR consulting firm HR Partners. Today's presentation is a 5-minute summary of the key provisions of the new New Jersey Equal Pay Act. I hope you find it informative. The first provision that's different than the Equal Pay Act is that this act applies to all New Jersey employers regardless of size. It covers all employees at locations within New Jersey, unlike the Equal Pay Act, which covers only one location. Monetary damages are much greater than under the Federal Equal Pay Act. Damages could go back 6 years from the date of the first discriminatory action. The law allows triple damages if the employer is found guilty. These high monetary damages could encourage your employees to file more complaints than under the federal act. This law also puts a greater burden of proof on the employer. In order to file a charge, the employee only needs to show that he performed similar work to another employee but was paid less. It is then up to the employer to prove that this was not due because of discrimination. One of the most significant differences is that pay comparison is to, quote, similar work rather than the same job as under the Federal Pay Act. Several states have adopted laws with similar wording and are struggling with defining what comparable worth really is. Most companies have pay grades, which include many jobs within the same pay grade, even though they may be quite different in nature. That could open up the courts to defining similar work as all jobs within the same pay grade. This could be particularly troublesome to those employers who use broadbanding with many jobs within the same pay band. The law prohibits employers from retaliating against any employee for discussing pay with any other employee. This may encourage your employees to request pay data about the pay of other employees. You may be prepared for this to happen and instruct your staff how to deal with these questions. The Act allows individual pay differences based on job qualifications, education, and experience. I recommend that these pay differentials be substantiated in writing, be realistic, and follow current practices. The Act also allows individual pay increases based on performance. Again, I recommend that different pay increases be substantiated in writing with specific performance examples or based on objective work measures. Knowing that what these provisions are and adjusting your policies to be equivalent is only the first steps you need to take as an HR executive. You really need to look at your practices from an audit standpoint. It has been my experience that most companies have inadvertent pay discrimination on the basis of sex or ethnicity. It is primarily due to past history and cultural reasons that women are paid substantially less than men, about 18% on the average. And there was a recent study last week in New York City that showed that Black females are paid 50% of white males. Those differentials can creep unknowingly into your pay practice. You need to be careful about doing an audit internally and have it done on the outside by someone like myself, because there was a court hearing several years ago that found that internal equal pay audits are discoverable in case of a lawsuit that cost AT&T millions of dollars because their internal audit self-incriminated them. If you want to know more about how to make sure that you are complying with this law, please give me a call at area code 908-763-5699. I'd also be happy to discuss any questions you might have. Thank you.